Uh, so can I start, sir?
Yes, please.
Good afternoon to everyone present here. I, Avneet Kaur, delegate of Sambhav Initiative and moderator of this event. On behalf of organizing committee, I extend a warm welcome to our esteemed dignitary, Mr. Panthil Majmudar, sir, and to all the participants in this fifth day of 10 days online national capacity building program for civil judges examination of Gujarat State Judiciary, jointly organized by Sambhav Initiative, which is working towards alternative dispute resolution, free legal aid, mental health, and treating legal literacy under the direction and guidance of Patron-in-Chief of Sambhav Initiative, Honorable Mr. Justice C.K. Thakkar, sir, former Judge of Supreme Court of India, and Patron of Sambhav Initiative, Honorable Mr. Justice M.R. Shah, sir, former Judge of Supreme Court of India, in collaboration with Gujarat High Court Advocates Association, which is a voluntary organization formed by Association of advocates regularly and ordinarily practicing in the Gujarat High Court with the purpose to promote professional goals, objects, and interests of advocate members in general, and is led by a total of 15 elected members. It holds legal seminars and study circles to keep the member advocates updated with the current legal development and Advocate Care Society. Where today's session is all about overview of the Code of Criminal Procedure 1973 and Bharatiya Nagrik Suraksha Sanhita 2023. Before we start the session, please adhere to some.
We are not able to hear your voice.
I request all the attendees to keep the microphones muted during the session. If you have any questions, please use the chat box or raise your hands. It is my privilege to introduce our esteemed dignitary, Mr. Panthil Majmudar, sir. Sir is a practicing lawyer with around 2 decades of experience, appearing before the Honorable Gujarat High Court, the Honorable Supreme Court of India, and Arbitration Tribunal. Over the years, Sir has appeared in various contested cases before the High Court of Gujarat. Sir is also a partner at S&P Majmudar Associates, a distinguished legal firm founded by Sri Shavil P. Majmudar and Sri Panthil P. Majmudar, mentored by Sri P.B. Majmudar, a senior advocate at Supreme Court of India and former judge of Gujarat, Rajasthan, and Bombay High Courts. The firm is renowned for its expertise in land laws, commercial laws, contract acts, and arbitration, contributing his expertise to the firm, We are deeply honored to have you with us today, sir. Over to you, sir.
Thank you so much. Thank you so much for your kind words. I hope I am audible to you.
Yes, sir, you are audible.
Okay, so I would straight away like to start with the topic since we are already a little late. The topic on which I'm going to speak today is about the overview of the Criminal Procedure Code as well as overview of the BNSS. That's the new code which has replaced the earlier CRPC. Now, as far as CRPC is concerned, we all know it was in force since number of years and it had come into effect in the year 1974. Since it contained provisions with regard to conduct of trials and with regard to hearing of appeals, revisions, as well as for bails, anticipatory bail, as well as the inherent powers of High Court. Some of the provisions were borrowed from the earlier code and had become a little obsolete. That may not be the exact right word, but those provisions were such which did need a relook. So instead of amending the code again and again, the legislature has now come up with the new procedural law, which is the Bharatiya Nagrik Suraksha Sanhita, that is BNSS, as you all are well aware. Now, as far as BNSS is concerned, there are certain glaring changes in the law. However, the core provisions, most of the provisions are almost the same as far as procedural aspects are concerned. What has been amended, or rather what new provisions have come into force, are with regard to the use of technology, the digitization of various procedures, and also provisions with regard to the liberty of accused and rights of victim, and also the provisions for registration of FIR, etc., anywhere, even if the police station has no jurisdiction. These are some of the provisions which have come into force in the new procedural law. I would first give you an overview on CRPC, and then I will take you to some of the changes which have been brought about in CRPC by BNSS, because other core provisions and the procedural aspects are almost similar in BNSS except the change of the section numbers. So I may not take you in depth with regard to provisions of BNSS. I may only deal with mainly the differences in the provisions or important changes which have come in the law. So first of all, let us start with CRPC. As you all are aware, CRPC was into force since the year 1973. It is known as the Code of Criminal Procedure 1973. It had first been enacted in the year 1882, and thereafter there were various amendments, and lastly the Law Commission was reconstituted in 1961, and pursuant to its report, which was submitted in the year 1969, it recommended the revision of CRPC. And based on those recommendations, a new bill was placed before the legislature, and thereafter the new CRPC came into force. And it came into force with effect from 1st of April 1974. It consisted of 484 sections, and there were 2 schedules also which were there along with CRPC 1973. So this is what the history of CRPC is. The main objects and reasons of CRPC, the main objects were, of course, to ensure that there is a fair trial to the accused. It also provided for the machinery for punishment of offences against the substantive criminal law. And also with regard to speedy delivery of justice, there were basic considerations in CRPC. And most importantly, it was an exhaustive code. The CRPC dealt with the main procedures of trial. The public prosecutor conducts the trial. The state is in charge of the trial over a period of time. Even in CRPC, there were amendments with regard to these provisions. And even a victim was given certain rights to assist the public prosecutor in conduct of trial, which rights subsequently were expanded, and even in the course of appeal, these rights were extended. In fact, a proviso was added to section 372 of CRPC, where it was also provided that a victim can even file an appeal against a judgment of the lower court which is against him with regard to sentence, etc. There was a provision which was brought into force by way of an amendment in the CRPC 1973. Mainly, before taking you through the important topics of CRPC, I would just like to give you a brief as to what CRPC 1973 dealt with. So the CRPC consists of various chapters where important definitions were also provided for in section 2. Those definitions mainly classified different offenses, such as what is a bailable offense, what is a non-bailable offense in IPC. These definitions are provided in section 2 in CRPC. Also, what is meaning of a charge? These definitions are there in section 2B of CRPC. Then it also defines a cognizable offense, non-cognizable offense. What are cognizable offenses is defined in section 2C. Non-cognizable offenses is defined in 2L. Similarly, what is a summons case is defined under section 2W, and what is a warrant case is defined under section 2X. There are numerous other definitions which you can go through in section 2. But these provisions are important provisions which you may come across in your daily life too, if you choose the profession or if you join the judiciary. These are some of the sections which you may have to deal with, because there are separate procedures prescribed for summons cases. There are separate procedures prescribed for warrant cases. So you must know what is a summons case and what is a warrant case. So summons case, if I may just read the definition, which is in section 2. Summons case is defined to be a case, you can also check the definition. A summons case which is defined under section 2W means a case relating to offense which is not a warrant case. And a warrant case is defined under section 2X. It means a case relating to an offense punishable with death, imprisonment for life, or imprisonment for a term exceeding 2 years. So there is a separate procedure of trial even for summons cases and warrant cases. So this difference between summons case and warrant case is very important, which you all must know. So basically, summons case is for an offense which is for not exceeding 2 years. That would be a summons case. All other cases would be tried as warrant cases. Similarly, the word complaint is also defined in CRPC, which also you all must take note of. Section 2D defines the word complaint, and it means any allegation made orally or in writing to a magistrate with a view to take action under the code that some person has committed an offense, but it does not include a police report. This definition also is important because there are provisions in CRPC and now BNSS with regard to conduct of trials which are based upon a police case and conduct of trials which are based upon a complaint case. So complaint essentially would mean a private complaint made before the learned JMFC, and it would not include FIR. So this is important. FIR is something which is defined under section 154 of CRPC. So these basic differences you must know, since there are the procedures of trial as well as for taking cognizance in case of some offenses under IPC are prescribed, and there are certain bars also under CRPC. For example, under section 195 of CRPC, there are special provisions with regard to taking cognizance, and it is provided that no court shall take cognizance of certain offenses prescribed in section which are there in section 195 subsections, except upon a complaint in writing by the concerned person authorized. So this complaint would mean complaint under section 2 subclause D, which would mean a written complaint or an oral complaint, but a private complaint made before the judicial magistrate. So for example, there are offenses under the Mines and Minerals Act where there is a bar contained in that special act under section 22, which says that no cognizance can be taken of such offenses except upon a complaint in writing. So in such offenses, if police registers FIR and a charge sheet is filed, the learned magistrate can refuse to take cognizance of this charge sheet because it is not a complaint. It is not a complaint as defined under section 2D of CRPC. So these are some of the important and basic provisions which you will come across as you progress in your career or in your profession, which important differences you must know with regard to what is a complaint and what is a police report. Police report means popularly known as what is known as charge sheet under section 173 of CRPC. And a charge sheet, I will deal with that a little later because those provisions will come when FIR is registered under section 154 of CRPC. Thereafter, police investigates the offense and then the police files the charge sheet, which is popularly known as the police report or final report under section 173 of CRPC. Now, with regard to some of the important provisions in CRPC, there are provisions with regard to conduct of trial by public prosecutor. However, there are also important amendments in such provisions. One provision being in CRPC section 24(8), and corresponding provision is also there in BNSS, which permits a victim also to engage advocate of his choice, but he can assist the prosecution. That is the provision under section 24(8). This provision over a period of time has been interpreted by Supreme Court, and recently Supreme Court has even taken a view that a victim has a right to participate in every stage of a criminal case, and therefore the honorable courts do permit a victim to engage advocate and to present their case. But basically it is the state which is prosecuting a crime. State is the prosecuting agency, and therefore in a trial, it is the public prosecutor only who would be conducting the cross examination, etc., of the concerned persons, witnesses, and therefore a victim, though can engage an advocate, basically he can assist the public prosecutor who thereafter conducts the trial. So this is one of the important provisions. However, participation of an advocate of a victim to orally argue, the courts generally will not prevent, and they do permit victim's advocate to argue orally also, but it is subject to permission from the honorable court. Otherwise, the provision of law is that he can assist the prosecution. Then there are substantive rights which are of course provided for to the victims now in BNSS, also in CRPC. There are some right of appeal, etc., which have come by way of an amendment. I will take you through that provision also a little later. As far as cognizable, non-cognizable offenses, again I told that those are defined under CRPC, that is under section 2C and 2L. And the cognizable case is a case, means the definition reads that cognizable offense means an offense for which, and cognizable case means a case in which a police officer may, in accordance with first schedule or under any other law for the time being in force, arrest without warrant. So these are all cognizable cases. There are cognizable cases in the schedule to CRPC also. It is mentioned which offenses of IPC will be cognizable. More serious offenses are generally made cognizable. Less serious offenses are generally not cognizable. Of course, there are again some state amendments and state notifications by which, though under the schedule to CRPC, certain offenses are stated to be non-cognizable, but in a particular state, they are made cognizable. For example, section 5062 of the earlier IPC is non-cognizable in the schedule to CRPC. But in Gujarat, by way of a notification which was issued under the Criminal Procedure Act of 1933, this offense is made cognizable. This is as far as 5062 of IPC is concerned. So for cognizable offenses only, FIR can be registered under section 154 of CRPC. So this is another important provision which you all must know, because a police, if they register FIR for a non-cognizable offense, then such FIR would not be maintainable. Such FIR can't be proceeded further, and in such cases, the entire action of police will be wrong. It will be without jurisdiction. So it is very important that you know the difference between a cognizable offense and a non-cognizable offense. Then, of course, there are rights of prisoners. The provisions were provided in CRPC under 41D. Also, there were substantive provisions and amendments brought to CRPC by section 41A was also introduced, where the offenses were punishable with up to 7 years, etc. Police was required to give reasons for arrest, and they cannot straight away arrest the accused. Corresponding provision in BNSS is section 35(3), and 41A of CRPC is also interpreted by the Honorable Supreme Court in the judgment of Arnesh Kumar, where various guidelines have been stated as to how a police officer has to react in cases which are punishable up to 7 years. Maximum sentence is provided for an offense. Then how the police should proceed in such cases. Those provisions have been explained, interpreted by Honorable Supreme Court in the case of Arnesh Kumar. You must also go through that judgment. The guidelines in those judgments are very important, and what and how the police officer should do and how he has to give reasons before arrest is something which is very important for protecting liberty of the citizens. And these are provisions which protect the liberty of an accused if he is being charged with offenses which are not that serious in nature. For example, 498A cases, in those cases, police automatically should not arrest the husband or the in-laws, but they should see to it that only if there are grave circumstances, if the accused is not responding to their notices or summons, in that case, they can probably go before the learned magistrate, give reasons for arrest, and if the learned magistrate authorizes the arrest, they may arrest the accused. Thereafter, the provisions with regard to registration of the first information report. These provisions in CRPC, they are contained in section 154. So this is a section which, as I told you earlier, this is a section which provides that only in cognizable offenses police should register the FIR. Such information can be oral or it can be in writing. Even if it is oral, police is bound to register the FIR, and such FIR has to be reduced to writing by such police officer. Under CRPC, it is also important to note that there was no provision that if a person approaches a police station which does not have jurisdiction to register FIR, in that case, what is to be done? The police used to sometimes register 0 FIR and send it to the police station concerned, which had jurisdiction. But now in BNSS, the corresponding provision to section 154 of CRPC has specific provisions for such eventualities, and the corresponding section to section 154 clearly provides that even a police officer can reduce to writing information provided it is for a cognizable offense. Even if he does not have jurisdiction, the section is section 173 in BNSS. It also provides for registration of electronic FIR. So this is an important change which has been brought about in the law. So section 154, which I was referring to, has also been interpreted by Honorable Supreme Court in the judgment of Lalita Kumari versus Government of Uttar Pradesh. This is also one of the landmark judgments of Supreme Court, which you all must know, because sometimes what happens is that the police may not register FIR even if it is disclosing a cognizable offense. For example, there is a cognizable offense committed with regard to cheating or something very grave in nature, but still the police may say that no, we will not register FIR. So in such cases, the Constitution Bench of Supreme Court has held, even in the case of Lalita Kumari, that once there is a cognizable offense, police cannot refuse to register FIR because section 154 mandates that FIR is to be registered. This judgment subsequently has been interpreted in number of judgments, including one judgment of Sindhu Janak Nagaroje versus State of Maharashtra, where also it has been held that registration of FIR is mandatory if there is a cognizable offense. Of course, the Supreme Court has also interpreted this provision and stated that in certain cases such as matrimonial disputes or matters where there is, for example, a case of medical negligence, in such cases the Supreme Court has said that police may conduct a preliminary inquiry, and after conducting preliminary inquiry to inquire whether a cognizable offense is disclosed. If it appears that there is a cognizable offense, police must register FIR. But such scope of preliminary inquiry is not for the purpose of ascertaining whether accused has committed the offense or not. The scope of preliminary inquiry is to inquire whether there is actually a cognizable offense made out or not. So police cannot say that accused is innocent and therefore we will not register FIR. That discretion is not available with police. Similarly, there may be cases where the police refuses to register FIR. In that case, the remedy available to a complainant is also something which you all must know. The complainant can also file a private complaint before learned JMFC. However, he can also file a writ petition before Honorable High Court with a prayer that these are cognizable offenses. Police is in failing in its duty to register the FIR, and therefore please issue a writ under the Constitution of India, writ of mandamus, to the police to register the FIR. In this situation, also Supreme Court has stated in case of Sakiri Vasu, also in various other judgments, that the parties must not rush to the Honorable High Court, and in fact they should first avail the remedy to file a private complaint before the learned magistrate, who may then decide either to take cognizance of the offense himself, or he may order a police inquiry under section 202 of CRPC, or the learned magistrate can also order registration of FIR under section 156(3) of CRPC. At the same time, if the facts are glaring, for example, in a case of murder, if police refuses to register FIR, the High Court would always have the jurisdiction to direct the police to register FIR and not relegate the concerned informant to approach the learned magistrate. So it is a matter of discretion, and it's the prerogative of the Honorable High Court whether to exercise its extraordinary jurisdiction which is vested in it under Article 226 of Constitution of India. Then as far as we are on the registration of FIR, as far as sections which are concerned pursuant to section 154, the next section is section 155, which deals with the provisions with regard to non-cognizable cases. So as I told you earlier, cognizable and non-cognizable offenses are defined in CRPC. In a case where the information is for a non-cognizable offense, the procedure which is to be followed is provided for under section 155 of CRPC, and then that is how the further procedure is to be undertaken, where a report is to be made and then the court proceeds further. In non-cognizable offenses, there can be no FIR and no arrest of the accused by the police under section 154. The procedures therefore are different. Thereafter, the provisions which are important are with regard to investigation by police, which is provided in section 156 of CRPC. Also, the time limit for completing investigation, the time limit when a police can have custody of an accused and thereafter he has to be produced before learned magistrate is also provided in section 167 of CRPC. The provisions with regard to remand are under section 167, where first 24 hours police custody is legal, but thereafter the accused has to be produced before magistrate, and depending upon the nature of sentence for an offense, if the sentence is more than 10 years or if it is less than 10 years for the offense, in that event the police has the power to complete the investigation, that is to file the final report, popularly known as charge sheet, which is to be done within the time limits prescribed under CRPC, that is 60 days or 90 days. And if they do not do so, in that event the accused would be entitled for default bail. So default bail is also a right of an accused if police fails to file a charge sheet within the prescribed time limit. And this default bail is also a very important provision interpreted by Supreme Court in various cases, where once this right accrues, it is an absolute right and the court has no discretion to deny default bail if police has not filed the charge sheet within the prescribed time limit, and accused has also already applied for getting the default bail. Then the provisions with regard to closure of investigation, they are provided in section 173 of CRPC. Section 173 provides for filing of the final report. Now, final report can be either charge sheet or it can also be a summary. Charge sheet means when police collects the evidence and prima facie the police is satisfied that offenses are made out. In that event, the police files a final report, which is popularly known as charge sheet. And then the charge sheet is presented before the court of magistrate, and then further provisions with regard to trial would go on depending upon the nature of offense. If it is triable by learned magistrate, the learned magistrate will take cognizance of offenses, frame the charges and proceed with the trial. If it is by the learned sessions court, the case would be committed by my learned magistrate to sessions court, and then the sessions court would proceed with the trial. However, there are also provisions that if police is of the view that no offenses are made out, or rather if it is a civil dispute, then the police can file a summary report. There are three types of summary reports, which are A summary, B summary and C summary. C summary is filed by a police officer when police is of the view that the case is of such a nature which is a civil type of a dispute. Then a C summary is filed. A B summary is filed where a police officer is of the view that the case filed by the complainant is a false case based, it is a false allegation. Then a B summary is filed. Sometimes the police can also file B summary with prosecution, which means that if an accused, if a complainant has totally abused process, filed totally false FIR, police can not only say that it's a false case, but at the same time prosecute the complainant by filing a B summary with prosecution. Then the A summary report is there, which is generally filed if FIR is filed against an accused and in spite of best efforts. That would include issuance of warrant under section 70, proclamation under section 82 of CRPC. These are all the provisions for securing presence of accused. If after all best efforts police is not able to find an accused, police can file A summary, keeping investigation pending, provided as and when the accused is found, they would continue the same, but they may not continue it for time immemorial, and therefore they close the investigation by filing a summary report stating that accused is absconding or not traceable. So these are the provisions mainly with regard to filing of charge sheet. Also section 173 subsection 8 provides for further investigation, where there are provisions with regard to further investigation to be undertaken by police, and these provisions have also been interpreted by Supreme Court in number of cases with regard to whether a right of complainant is there to get such further investigation ordered, or it is only at the discretion of police, and at what stage whether such rights can be exercised. So that has been interpreted by Supreme Court. There were conflict of views. Certain views were to the effect that complainant cannot file an application for further investigation. However, recently there are views where it is held that complainant can also apply for further investigation. It is up to the learned magistrate ultimately to pass an order on such application. Then there are provisions with regard to cognizance of offences by magistrate. So as I told you earlier, once FIR is registered, the police files a charge sheet. Charge sheet is then sent to the magistrate. If police does not register FIR, a complainant can directly also approach the learned magistrate. Once a complaint comes before the magistrate, there are 3 courses which are open to the learned magistrate for taking cognizance. That is provided for under section 190 of CRPC. The magistrate can either upon receiving a complaint, he can take cognizance. That is a complaint defined under section 2D of CRPC, a private complaint. He can take complaint upon a police report, which would mean the charge sheet under section 173, or he can even himself take cognizance, he can himself inquire into the case. So these are all provisions which are contained in section 190, and subsequent sections provide the procedures with regard to what a magistrate has to do. There are also provisions in section 200, 202, 204 with regard to police inquiry, how a magistrate should proceed, and if a magistrate finds that a complaint is absolutely bogus, he can even dismiss a complaint under section 203 of CRPC. And if a magistrate takes cognizance and decides to proceed further with the case, then a summons or a process is issued under section 204 of CRPC to the accused. In these provisions, there is a difference in BNSS, where in CRPC there was no provision that an accused can participate in a inquiry at the stage of inquiry before learned magistrate. However, in BNSS, in section 200, the corresponding provisions of BNSS, there is a slight change where it is provided that even an accused can probably participate and put forward his case before magistrate issues a process under section 204 of CRPC, that the corresponding provisions of BNSS. So these are some of the important changes which have come up in BNSS. Then the procedures with regard to taking cognizance in certain cases is also provided in section 195 of CRPC, which I already referred to earlier. So that is also one of the important provisions which all of you must go through, section 195 of CRPC. And with regard to certain class of offenses, such as sections 173 to 188 of IPC, there are some special provisions which would bar taking of a cognizance by a magistrate under section 195 of CRPC unless the complaint is filed in such a case, and therefore police cannot file a charge sheet in such cases, and it has to be a private complaint only which should be filed. Then only the learned magistrate would proceed further to take cognizance of such offences. Then there are procedures in CRPC with regard to the conduct of the trials. There are different provisions which are provided. First of all, there are provisions from section 225 to 237 of CRPC. They deal with trial of warrant cases. Warrant cases I already referred to earlier. What is the meaning of warrant cases? And these are the provisions which contain, this is the with regard to, as far as 225 to section 237 are concerned, these are with regard to trial before a court of session. So initially the case is to be conducted by the public prosecutor. These provisions have been provided. Then there is a right of an accused to file a discharge application, which is provided in section 227 as far as sessions tribal cases are concerned. Section 227 provides for discharge application. So discharge application means that if an accused is able to satisfy the learned sessions judge that on reading of all charge sheet papers, if no prima facie case is made out, or there is no ground to frame the charges, in that event an accused can file a discharge application, and he can request the learned sessions judge that he should be discharged, he should not be compelled to face the trial, and no charges should be framed against him. So these are the provisions which are contained in section 227 for the discharge of an accused before a court of session. Then if the learned sessions judge believes that there is a prima facie case, then a charge is to be framed. That is under section 228 of CRPC. So what will be the contents of charge, etc. All this is also provided in the CRPC. And once a charge is framed, the trial proceeds in the manner provided in sections 229 to 237. That is, first of all, the plea is recorded of the accused. The accused, if he pleads guilty, that would be the end of the matter. But if he pleads innocence, then he has to be given a fair opportunity. The public prosecutor would then get a date fixed for prosecution evidence. The entire evidence is to be led, oral as well as documentary. Cross-examination of witnesses takes place. The defense counsel gets full opportunity to cross-examine the witnesses, and thereafter the accused also gets opportunity to present his evidence if at all he wishes to do so. And then lastly, final arguments are heard of the prosecution as well as defense, and then the judgment is to be pronounced. Even provisions with regard to judgment are there in section 235 of CRPC for trial before a court of session. Similarly, there are provisions for conduct of trial of warrant cases by magistrate and trial of the summons cases. Trial of warrant cases is provided for in chapter 19 of CRPC. As far as this is for the offences which are triable by learned magistrates court. So JMFC triable offences or magistrate triable offences or offences triable by court of session, this is also classified in the schedule to CRPC as to which offences are triable by learned magistrate court and which offences are triable by learned court of session. Then they will be either warrant case or summons case. So first, the cases which are warrant cases, its procedure is prescribed under chapter 19, warrant cases to be tried by learned magistrate. Now in these cases also there are two types of cases. One is cases which are instituted on a police report, and another is cases which are instituted otherwise than on a police report. So a case which is instituted on a police report, it would mean a case which is instituted on a charge sheet and not on a private complaint. So police report, as I told you earlier, it means the final report under section 173 of CRPC. So those cases where there is a charge sheet filed by police, the procedure of its trial is different, and those cases where police is not involved, the magistrate takes cognizance on a private complaint. In those cases, the procedure which is prescribed is different. That procedure is provided for in chapter 19 subclause B, that is cases instituted otherwise than on a police report. So again, the procedure for police report is that there should be first compliance of section 207 with the learned magistrate must ensure. Thereafter, again, there are provisions for discharge of an accused under section 239 before the learned magistrates court. Then, if he is not discharged, the charges are framed and evidence for prosecution and defense is led. So this is similar procedure as is prescribed for before a court of session. However, in cases otherwise than on a police report, that is in a case of private complaint. For example, in a case where a complainant chooses to file a private complaint under section 420 of IPC. In that case, he does not go before police, he directly approaches the magistrate. Then the magistrate issues process under section 204 of CRPC. Then the procedure which is to be followed is, first of all, there will be a pre-charge evidence. Pre-charge evidence is to be recorded. After recording pre-charge evidence, charge is to be framed. Then again evidence is to be recorded. Post-charge evidence again is to be recorded. And thereafter, the entire trial is to be conducted after leading of evidence, and the judgment is to be pronounced. As far as these cases are concerned, there is also a provision for discharge provided for in section 245 of CRPC, where it is provided that in such cases a discharge application can be filed at any stage, that is at pre-charge evidence stage also, as well as post-charge evidence stage also. In 245, this section is slightly different than the discharge provision contained in other two trials, that is trial in a case instituted on a police report and trial before a court of session. In those two cases, after charge is framed, no discharge application is maintainable. But in these cases, under section 245 of CRPC, you can file a discharge application post-charge, pre-charge at any stage, that is the provision. Then there is also a provisions with regard to trial of summons cases by the magistrates, which is contained in chapter 20 of CRPC, where again the procedure is slightly different. You can go through sections 251 onwards, which provides this procedure. In summons cases, the learned courts would only state the substance of accusation to the accused, and a formal charge will not be framed. This is a major difference as far as summons cases are concerned. And in summons cases, there is no provision to file a discharge application. So in Negotiable Instruments Act, though the procedure which is to be followed is of a summary trial, but if evidence is recorded in full, in that event, it is considered as a summons case. And in those cases, Negotiable Instruments Act type of cases, there is no provision to file a discharge application. So one question may arise as to what would be the remedy for an accused in such cases if he wants to avoid facing the trial if a case is totally wrong. Then the accused can always file a petition under section 482 of CRPC, which provides for quashing of a criminal case. If the accused is of the opinion that no prima facie case is made out, or the criminal case is totally an abuse of process of law. 482 of CRPC I will deal with at last when I conclude CRPC overview. So I am not dealing with that in detail right now. First, I may just conclude the remaining important provisions. So there are again provisions with regard to summary trials, plea bargaining, and all those provisions are provided for in CRPC. The language of courts are also provided for in section 272 of CRPC. Also, there are provisions with regard to commissions for the examination of witnesses, which are from section 284 onwards. Then there are general provisions with regard to inquiries and trials from section 300 onwards. Section 300 again is an important provision because it provides that no person can be acquitted or convicted for the same offense more than once. So an accused cannot be compelled to face trial for same offense for which he has already been tried once, and section 300 protects his rights for such event, which is popularly known as auto fois acquit, auto fois convict. So this provision, the Constitution of India also provides certain safeguards under Article 20 with regard to the liberty of an accused and rights of an accused. And therefore, if an accused has faced one offense, if another offense is registered which is part of the same transaction for which the first FIR is registered, in that case he can always say that this second FIR is a successive FIR. It is for the offense which is part of the same transaction for which one FIR is already registered. So I may not be compelled to face this trial. He can even file a quashing petition under section 482 of CRPC, praying to quash such successive FIR. In this regard, one landmark judgment is in the case of Amit Bhai Shah, where Honorable Supreme Court has clearly explained that what will be a successive FIR, what can be considered to be part of the same transaction for the offense to be a successive offense, and all these provisions have been interpreted by Honorable Supreme Court of India in that case. Then there are provisions in CRPC with regard to the general provisions. Another provision which is important is section 311 of CRPC. It provides for power to summon material witnesses or examine person present. So section 311 of CRPC also provides for recall of witnesses who have already been examined. So in order to see to it that proper justice is done, if it appears to the Honorable Court that a witness who is already examined is required to be recalled and re-examined or again cross-examined on certain aspects, then section 311 powers can be used. As far as this is concerned, it would be completely discretion of the Honorable Court. But any party can file such application and the Honorable Court can decide the same. There are judgments which have taken a view that such powers cannot be utilized to fill up the lacunae which have been left out during cross-examination. For example, there may be cases where in a case where one witness is examined, thereafter the accused enters into a settlement with that witness and then files an application to recall such witness. In that case, the court may say that no, this is not permissible and this is for filling up lacunae, and you cannot re-examine or recall such witness and examine him again. Similarly, there may be provisions, there are provisions with regard to further statement of an accused which are provided for in section 313 of CRPC. This is also a very important provision and important right of an accused. And in the further statement, the accused is put to all the questions, the circumstances against him, which he must answer. And this is something which an accused can properly use for defending himself in a criminal trial. Then there are provisions with regard to offenses which are affecting the administration of justice. These are provisions contained in section 340 onwards in CRPC. Again, these provisions are very important because there are special provisions with regard to perjury, etc. And these are offenses which affect the administration of justice. So some safeguards are also provided in these sections. Some specific procedure is to be followed in order to ensure that the provisions are not misused. And there are special provisions which are provided for in chapter 26 of CRPC. Then the other provisions which are important in CRPC are with regard to right of appeals. So these provisions are contained in chapter 29 of CRPC. Section 372 initially provided that there will be no appeal unless otherwise provided for in CRPC. Then a proviso has been inserted to this section which has been amended, where a victim is also given a right of appeal against a judgment if he is aggrieved by the acquittal of accused or for a lesser sentence. So a victim can also file an appeal as per proviso to section 372 now. This provision recently also Supreme Court has interpreted and stated that even in cases of 138 of NI Act, a victim can file an appeal under section 372. In earlier view was that a victim in such cases where there is an appeal provided for by the complainant in section 378 of CRPC cannot file appeal under proviso to section 372. But this provision is undergoing interpretation, and there are recent interpretations which take a view that he can choose either section 372 or section 378 of CRPC. Section 378 of CRPC provides for appeal by way of special leave which can be filed by a complainant in cases which are instituted on a private complaint. So again, that is the reason I started by explaining what is a complaint under section 2D of CRPC, because these provisions keep on coming at various stages in CRPC and now BNSS. And under 378, a special leave is required to be asked for by the complainant, but a complainant's right of appeal under section 378 of CRPC is only in cases which are instituted not on charge sheet, not on police report, but on a private complaint, which is under section 2D of CRPC. So in cases where FIR is not there, in those cases only complainant can file appeal under section 378 of CRPC, which would lie before the Honorable High Court and not before the lower courts. He can directly come before the Honorable High Court. Then there are provisions, various provisions with regard to appeal in case of acquittal, also with regard to appeal for enhancement of sentence which state can prefer under section 377 of CRPC. Then there are provisions with regard to abatement of appeal, summary dismissal of appeal, and the powers of appellate court. This is also important. Also, appeals against conviction are provided. Accused can file appeal under section 374 of CRPC. And as far as powers in appeal are concerned, it is provided for in section 386 of CRPC. And these powers are very important. In fact, they have been interpreted also in various judgments that in appeal against conviction, the court can reappreciate the evidence. The powers are much wider than the revisional powers under section 397 read with section 401 of CRPC. So appeal is continuation of proceedings of trial. So the Honorable Appellate Court can reappreciate the entire evidence and thereafter independently arrive at its conclusion with regard to guilt or innocence of an accused. And section, as far as these appellate powers are concerned, again it depends upon the nature of appeal, because in an appeal against acquittal, which is filed before Honorable High Court, the powers are little bit different, where Supreme Court has taken a view that even if the appellate court is of the view that conviction should have been recorded, but merely because a second view is possible, if the first view of acquittal is also a possible view, then that view should not be disturbed in an acquittal appeal. So this is also important provision, that acquittal appeal scope is limited, whereas scope of a conviction appeal would be different. Then there are further provisions with regard to the reference and revisions. Revisional powers are provided for under sections 397 read with 401 of CRPC. There are judgments which have taken a view that in revisional powers, the courts cannot reappreciate the entire evidence, but only if the view of the lower court is totally perverse or it has resulted into miscarriage of justice. In those situations, revisional powers can be exercised and the findings as such can be interfered with. Also, in a revision against an acquittal, there are judgments which have taken a view that the revisional court cannot convict the accused but can remand the matter and send it back to the trial court. So their scope and the powers of a revision application are quite limited as compared to a criminal appeal. Then there are provisions with regard to sentences, bails, etc. Important provision with regard to bail. Most of you must also be knowing that they are anticipatory bail and regular bail. Section 438 provides of CRPC provides for anticipatory bail. Similar provisions in BNSS are also there with some amendments. And Section 439 provides for regular bail when an accused is in jail. There are also special provisions for bail under Section 437 of CRPC, and there are also provisions for old aged infirm persons as to their bails can be considered more liberally. Then as far as anticipatory bail is concerned, the landmark judgment is in the case of Gurbaksh Singh Sibia versus State of Punjab, and which has now been also considered in the case of Sidram Mehetre. As far as regular bail is concerned, 439 landmark judgment is in the case of Sanjay Chandra, where again Supreme Court of late has been stressing that the incarceration, that is the sentence if accused is such that it is for, say for example, for 10 years. If an accused is in jail for more than 5 years, then his bail applications should be considered liberally, as otherwise this would amount to conviction before trial. Also, as far as regular bail is concerned, in cases which are triable by learned magistrates court, which are not that serious in nature, there are judgments which have taken a view that the bail should be considered more liberal. At the same time, rights of complainant, accused, as well as the state have to be balanced. So these are the provisions. Everything as such is provided for in CRPC. You all must remember that in criminal cases, criminal trials, procedures, appeals, revisions, there cannot be an application which can be filed without support of a provision of law provided for in the procedural code. So it's a totally exhaustive code. It provides for all provisions with regard to the procedures which are to be followed in a criminal case. Then there are also provisions with regard to compounding of offense, which I must also point out. It is also an important provision, section 320 of CRPC. It also provides as to which offenses can be compounded. Compounded means which can be, in ordinary parlance, we can say, which can be settled. So there are some offenses which are not very serious in nature. They are permitted by the Code of Criminal Procedure to be compounded. At the same time, there are offenses which are non-compoundable, which even if parties settle, for example, case of murder, the learned Sessions Court or Court of Magistrate cannot permit parties to settle such disputes. There are also judgments which have taken a view that in certain non-compoundable offenses, for example, 498A of CRPC is non-compoundable. But since it is not affecting the society at large, it is not an offense against the society. Supreme Court in the landmark judgment of Gyan Singh has taken a view that such offences can be quashed by Honorable High Court of Gujarat by exercising powers under Section 482 of CRPC. So now I straight away come to Section 482 of CRPC. That is also one of the important provisions in under the code, because it provides that to prevent abuse of process of court or to secure the ends of justice, Honorable High Court can exercise powers under Section 482 of CRPC. Basically, it's a power where Honorable High Court can almost do everything except make man a woman and woman a man. To secure the ends of justice, the Honorable High Court can exercise such powers. So these powers, where, for example, absolutely false FIR is registered, or for a cognizable or a non-compoundable offense which is not affecting the society at large, there is a settlement. A party can approach the Honorable High Court under Section 482, request for quashing of such criminal prosecution, and Honorable High Court can quash such prosecution, and that is how this provision works. So these are mainly the important provisions of CRPC which are there. Now the CRPC has been replaced by the BNSS. Now why this need arose, that in a separate, I have provided, you can see the screen. as to why this need arose to replace the CRPC, because some of the provisions of CRPC had become outdated. There was no electronic communication, digitalization of the use of machinery, etc. So for all these things, there was a need to change the CRPC, and now it has been replaced by BNSS. BNSS also provides for some even speedier and accessible justice. There are provisions which are there with regard to victims' rights also in BNSS, which are little wider than the CRPC, and therefore this new code came, the new procedural law came into force. Essentially, the basic provisions with regard to appeals, revisions, bails, etc., the trial procedures are almost similar to CRPC. The BNSS retains the skeletal structure of CRPC with regard to investigation, inquiry, trials, and appeals. However, BNSS is more citizen-centric model. So it ensures that apart from state, even the individuals do have certain rights. And there is also more emphasis on the time-bound stages, rights of victims, and technological integration as far as BNSS is concerned. And thereafter, the BNSS has 531 sections, CRPC had 484 sections. Then as far as BNSS is concerned, there are provisions with regard to arrest which are made even more elaborate. Then where there is a section 35 in BNSS which provides that arrest is only necessary if it is for further offense, proper investigation, ensuring court appearance in less serious offenses. So there are provisions which safeguard the liberty of an accused. Then again, with regard to registration of FIR, as I had told you earlier, there is recognition of the zero FIR and e-FIR in section 173 of BNSS. Also, forensic investigation is mandatory for offenses punishable for more than 7 years. This is provided for in section 176 of the BNSS. So these are some of the important provisions with regard to BNSS. Then there are also provisions with regard to remand of accused. The timeline for investigation is provided in section 187 of BNSS. Also, there is a detailed framework for regular and anticipatory bail, which is provided for in sections 479 to 482 of BNSS. And default bail also provisions are there in 187 of BNSS. There are also summary trials which are now expanded for offenses which are punishable with fine of 20,000 or less. Then there are provisions for trial in absentia in case of absconders with safeguards, which are provided for in sections 346 to 351 of BNSS. Then BNSS also has introduced section 193(3), which provides for a victim's right to oppose withdrawal of prosecution by state. This was not there in CRPC. So victims' rights and their rights are recognized in a more wider manner by the BNSS. Then victims have also rights to assess the FIR charge sheet judgment. These provisions are provided for in section 193(4) of BNSS. Basically, the Supreme Court judgments which had emphasized victim-centric justice and fair trial framework, all those judgments have now been considered and relevant changes have been brought into effect by introducing BNSS. Then there is also provisions with regard to use of technology and digitization. These are provided for in sections 532, 530 of BNSS. There are also provisions with regard to cyber evidence, forensic handling, and various other provisions for time-bound filing of reports, digital evidence, etc., which are there in the BNSS. Then video conferencing is also now recognized for recording of evidence, trials, etc. This is also an important change which has been brought by introducing BNSS. So these are some of the important changes which have been brought into force. The chapter-wise overview also I have provided for, which you all can go through in BNSS. since BNSS is now in force, you must remember the sections of CRPC which are now corresponding to the sections of BNSS. Also, as far as BNSS is concerned, there is it aims to streamline and modernize the criminal procedure. That is the main object of BNSS, and it also protects the rights of victims and accused alike. So this is mainly the provisions of BNSS which are important. Then as far as the law is concerned, this would be the overview which I can give to you as far as CRPC and BNSS is concerned. And basically, these procedural laws are exhaustive. I would ask any one of you if you have any questions. As far as the provisions are concerned, it's a topic which can go on and on. It's a very lengthy procedural code. But these are the provisions which probably can help you in your life in future also when you join the profession or service. And these are some of the provisions which you will come across in your daily practical life when you join the profession or when you go for service or go for your further prospects. So these important provisions all of you must keep in mind. At the same time, I would like to tell you that you must also keep in mind that bookish knowledge may not help all of you. Ultimately, you will have to face the actual proceedings. It is only thereafter that you can learn and you can actually get into details of these provisions. I would also like to tell you that you must all go through the judgments of Honorable Supreme Court which are reported in Supreme Court cases or GLR, GLH or various other law reports. And while reading these judgments, you must not only read the head notes, but you must read the facts of the case, what the arguments are made, and what is the ratio of that judgment. That is very important. And for the procedural law, you all must remember that ultimately procedure is handmaid of justice. So procedural law is handmaid of justice. The honorable courts have interpreted such procedures in such a way that they benefit the concerned party who is before the honorable court so that they get justice. So ultimately, procedure is handmaid of justice. But as far as criminal law is concerned, strict adherence to these provisions for filing applications, etc., is very much necessary and mandatory. And you cannot, as of right, claim certain things, though procedure is handmaid of justice. You can't say, for example, in a non-compoundable offense, you cannot tell the learned magistrate to permit compounding. That is something which would not be permissible. So this is how the law works. If anything else is there, any questions, you can always ask me. But this is basically what the overview is.
Thank you so much, sir. Now we open the floor for question and answers. Whosoever have any questions, kindly raise your hands or you can write your question in the chat box. Sir, there's one question in chat box. When one accused plead not guilty, then after any stage of trial, he can plead guilty or not. Any case law.
No. As far as I told, there are provisions which are there in CRPC with dealing with the conduct of trials where there are specific provisions as to when he can plead guilty. That stage is there. Once that stage is crossed, the charge will be framed against him if he pleads not guilty. And if he pleads guilty, the trial will end there and there. Then, in that case, he will be sentenced accordingly. But you cannot, once that stage has crossed, subsequently you cannot change your stand. So once a charge is framed, you will have to face the trial full-fledged, defend yourself, and then prove that you are innocent. Though burden of proof will be on prosecution to prove that you are guilty. But it is at that stage that you will have to establish your innocence. You cannot get a second chance for recording of plea.
Sir, and after judicial custody, later on police custody can allow or not. Any case law on that.
Again, as far as police custody is concerned, the provisions of CRPC 167 corresponding provisions are there in BNSS. BNSS provides for different types of police custody. The earlier period was maximum 15 days and that too within first 15 days police custody was permissible. Now BNSS has changed that situation a bit, but at the same time, the maximum permissible police custody is provided. So once that period is over, there cannot be further police custody, then only judicial custody can be there.
The next question is under section 483 BNSS session court give bail. So magistrate have power to cancel that bail any circumstances, provision or case law.
Sorry, can you repeat the question?
Under section 483 BNSS session court give bail. So magistrate have power to cancel that bail any circumstances, provisions or case law.
No. Yeah. If one sessions court grants bail, magistrate cannot cancel it. The same court can cancel it for breach of condition, or you have to challenge that order before the higher court, that is High Court, and say that this order was wrongly passed. And in that case, the higher court can always cancel the bail which is granted to the accused.
Sir, can the police apply for remand after the accused gets anticipatory bail?
Now, recently, the Supreme Court has clarified this aspect. There was a case from Gujarat itself where once anticipatory bail was granted, the police had applied for remand. So the accused had filed a contempt petition before the Supreme Court, stating that this is not permissible. Supreme Court has also clarified that it is not permissible. Once anticipatory bail is granted, there cannot be remand of an accused, because that would also amount to custodial interrogation, which is not permissible once anticipatory bail is granted. So there can be no remand after an accused is granted anticipatory bail.
Sir, one last question. Court can take further statements with plea before cross-examination of complainant in NI case.
In further statement, I could not get the question. What's the exact question? In Negotiable Instruments Act, you mean to ask, right?
Yes, it is written NI case, sir.
Okay, so they can take further statement with the plea. No, that can't be done. The plea is to be recorded in NI Act. The provisions with regard to summons case trial would apply. So those provisions will have to be followed. Trial of summons case provisions you can go through in the Criminal Procedure Code or the BNSS. Trial of summons cases.
Thank you, sir, for this wonderful session. And on behalf of organizing committee, I extend my deepest gratitude to you, sir, not only for accepting our invitation, but also for this wonderful session. And also, I would like to express my deepest gratitude towards Patron-in-Chief of Sambhav Initiative and Patron of Sambhav Initiative, Honorable Mr. Justice C.K. Thakkar, sir, and M.R. Shah, sir, under whose vision and guidance we were able to conduct this session on 10 days online national capacity building program for civil judge examination of Gujarat State Judiciary. And thank you all the participants for joining. Thank you so much, sir, once again.
Welcome.